Will I have to pay alimony in divorce? Hi, I'm Bill Farias, founder and CEO of Farias Family Law. We are a divorce and custody firm in Southern Massachusetts, and this is a very common concern. The high earner is moving toward divorce and is afraid that there is going to be a sizable alimony order, and that's going to disrupt his or her finances. So the purpose of this video is to help you understand when alimony is ordered, under what circumstances, and how it's calculated. So question number one, is alimony appropriate for your particular circumstances? And there are a couple of factors that we found are most important. There are many factors that go into alimony, but one is length of the marriage. And this doesn't mean that there aren't alimony orders on short-term marriages, because there are. However, generally, the longer the marriage, the greater the risk that there is financial dependence from the lower earning spouse to the higher earning spouse. So it's just natural that the longer people have been married, the more likely it is that one person will become financially dependent on the other. So length of the marriage tends to be an important factor. In determining whether alimony is appropriate, you are looking at the higher earner's ability to pay and the recipient's need. And so obviously, the greater the disparity in income between the parties, the more likely it is that there will be an alimony order. So the longer the marriage, the more likely that there will be alimony. And also, the greater the financial disparity, the more likely it is that there will be alimony. And the main test is need. So the need of the recipient and the payor's ability to pay. In terms of how it's calculated, the actual law, the statute, says that it is the lower number of the parties' need. So how much money does that person need to live a lifestyle that's at least comparable to the lifestyle that person was living during the marriage? The actual calculation that's in the statute to assist with arriving at this number is the statute recommends 30 to 35% of the difference between the parties' gross income. So you take the higher earners' income minus the lower earners, and you multiply that by 0.3 or 0.35, somewhere in the middle, and that gives you the number per the statute. However, as of 2019, alimony is no longer taxable or tax deductible, and that makes a huge difference, right? So before 2019, someone's paying alimony, they're at least getting a tax break on that money or on that expense. They are no longer getting that. And so what the courts have done generally is the courts have reduced that percentage to, in our experience, it's been anywhere from 22 to 29%. So this isn't black and white. It isn't written in any case law. But as a matter of practice, this is what most judges are doing, is they're decreasing the percentage to account for the fact that alimony is no longer tax deductible. So in trying to calculate alimony, you're looking at what is the recipient's need? What do they actually need to get them to a place where they're living a lifestyle that's at least comparable to what they lived during the marriage? And you're also looking at that number, 22 to 29%. We usually use about 25, 26% of the difference between the gross incomes. Whichever of those numbers is lower should be the alimony amount. If you have any questions about this, you have any questions about your risk of alimony, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, subscribe to our channels. You can find us on social at Farias Family Law. Thank you. Have a good day.